you Shanna King?
Yes, ma'am.
And Mr. Wilkerson, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Ms. King, in cause number 250295, you're charged with a second-degree felony offense of burglary of a habitation, and that's from December 13th of 2024. And how do you plead to that charge?
Guilty, ma'am.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Wilkerson?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. King is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of that plea, find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a habitation, sentence you in accordance with your agreement to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Wilkerson. All right, good luck to you, ma'am. You can go back with the bailiff.
Do I take this with you? Okay, thank y'all.
Good morning. Are you Johnny Jacobo Ramon?
Yes.
And Mr. Ramon, you were previously in court and entered a plea of guilty to the second-degree felony offense of accident involving death. And that was a plea agreement of a cap of 15 years in prison. I have received the pre-sentence report. Has everyone had an opportunity to review that report?
Defense has. Yes, Judge.
Are there any additions or corrections?
No, Your Honor. Not from the state.
Mr. Burbank, you may proceed.
Your Honor, this is a tragic accident. If you read the factual basis, which I know you did, a person was walking across the street at nighttime, and cars swerved, and my client actually hit him. As reflected by the charge, he failed to stop. He panicked, as in reference to his version, that is on page 1, and then was stopped up in Lumberton. He's been employed. He has family up in Woodville. He's been employed. He's got one problem. He is not a U.S. citizen. I would be arguing for probation in this case, but it is my understanding that there is a hold on him by immigration, and that he probably will not, if he got probation, he wouldn't be released. He has 2 prior DWIs from Tyler County that were taken care of. At the same time, what you receive, basically time served, 90 days jail. The intoxication charge that I believe were rejected by the, and probably because we're down here, that's how we did it. Your Honor, I asked for there's a death involved, and I would would love to have the minimum in reference to penitentiary time, but I'm asking for mid. I think that 15 is probably too harsh, and that's my opinion, especially in light of the facts and circumstances of this, in which the person was walking across the street at the time and being blocked by other vehicles, and other vehicles had to get out of the way. But he was definitely wrong in not stopping, and he was intoxicated. I would ask for anything less than the 15 because I know where he's going to go, and that's a sad thing, but he's not here legally, and I don't know if he would like to address the court.
Sí,
Yes, sí.
Go ahead.
quiero decir que lo siento, que si lo hubiese visto, yo me hubiese detenido antes para poder auxiliarlo, pero pues
Hold on.
Judge, I'm so sorry. Had I seen him, I would have stopped and helped and rendered aid.
pero pues había un carro con
Hold on. Hold on. So are you telling me that you didn't know you hit someone?
¿Me está diciendo que usted no sabe que le pegó a alguien?
No, sí.
I did know.
Okay.
Y pero pues había un carro enfrente y yo no lo pude ver
There was a
antes.
vehicle in front and I wasn't able to see him on time.
Okay.
Pero pues quiero decir que lo siento.
I want to say that I'm sorry.
Que si pudiera volver el tiempo lo haría, pero
But if I
sé
could
que
go back in time, I would go back and
soy
help.
el culpable.
And I know I'm guilty.
Okay. Thank you.
I just have one question up here. What were you doing for work?
¿Qué estaba haciendo de trabajo?
Court is in session, and things are about to get intense from burglary to deadly crashes today. Judge West faces back-to-back cases that'll test both justice and mercy. Let's see how each defendant's fate unfolds.
Estaba en el roofing.
I was a roofer.
And how long have you been? How long have you been in the country?
¿Cuánto tiempo has estado aquí en los Estados Unidos?
14, 15 años.
14, 15 years.
And have you always had a job?
¿Siempre tenido un empleo?
Sí,
Yes.
And you do have a
¿Y
family.
si tiene una familia?
sí.
Yes.
Thank you. Mr. Smith?
Judge, we would argue for the max sentence in this case on the plea agreement based on the fact that when he struck him, he knew that he struck him. That was evidenced by the phone calls the next day. He knew he hit a person. When he was stopped in Koontz, which is a long way from the accident scene, he told the police when they noticed the damage on his vehicle that he had struck a deer. They, either through dealing with him before or suspecting that he was lying and knew he was intoxicated, went all the way back to the county line looking for a deer that had just been struck. And only because they were diligent in doing so did we even know that he had committed this particular crime. He knew he committed the crime. He lied about it. He has an issue with alcohol. He's here in the country illegally. I would direct your attention to the jail report in this case and how he's acting, showing disrespect for staff as well as masturbating in open bunk. We ask for a 15-year sentence in this case.
Mr. Jacobo Ramon? Obviously, the facts of the case are terrible. The fact that you didn't stop. The fact that you were intoxicated. And in addition, and I'm not even sure that when you were in our jail for some amount of time, there was a requirement that I release you because of the amount of time that had gone from the time of the offense while you were sitting in custody. I did that, and then you didn't show up. You are here illegally and have now killed someone. I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. And at this time, find you guilty of accident involving death sentence you to 15 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. It is in Spanish. I advise you to read that. If you are ever back in Texas legally, you will not be able to possess a firearm or ammunition. That could lead to more charges against you. All right. Thank you. You can go back with the bailiff. Thank you, Mr. Burbank. Thank you, Ms. Burge. Good morning, sir. You're Corey Flemings. And Mr. Flemings has two cases, cause number 24-2144 and 24-2145, set for trial to begin with jury selection on Monday, the 23rd. And what is the announcement?
We'll be ready, Your Honor.
All right.
State's ready, as far as I'm aware, from Mr. Coleman, Judge. I would ask that Mr. LeBlanc make a request for the media if he has not done so already, since we have a bit of time in between.
Okay. Have you asked for and received the media?
I believe this is the one, yes, I've asked for it, but I haven't received it. I think I have it. I'll have to check if I have it at the office, but
It's
when you're right.
okay.
Ready.
Well, but if your client hasn't seen the videos or any type of media with you, then how do you know for certain that this is what is the appropriate?
6 years in prison. That's no small deal in Texas. Burglary of a habitation is serious business. The judge follows the plea deal, exactly showing how crucial it is to understand every line before you sign those papers. No last-minute surprises here, only consequences.
End game, because he hasn't seen. I would assume in an assault on a peace officer, there's body cam footage that might affect what agreement there is. Do you know if that is, can that get ready today?
Yes, Judge, it doesn't look like it was marked as requested and received, but I can follow up on it.
I want that done today.
Yes, sir.
I want you out to see Mr. Flemings by tomorrow
Yes, sir.
to review that with him, and I want to know by tomorrow at noon that it has been done and that in fact this is what Mr. Flemings wants to do, is go to trial after seeing that. All right? I want to hear from you at noon tomorrow. Okay. You can go back with the bailiff. Good morning. Are you Jennifer Bowles? And will Ms. Bowles waive the formal reading of the motion? Ms. Bowles, in cause number 18-29814, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 28th of 2019 for the offense of fraudulent use or possession of identifying information. That was a third-degree felony, and that was a 10-year deferred probation. Is that correct?
Yes, ma'am.
It alleges that you violated your probation. Count 1 alleges that you provided a urine sample October 24th of 2023 that tested, and October 25th, that tested positive for methamphetamines, amphetamines, and ecstasy. And is that true or not true?
True.
Count 2 alleges that you provided a urine sample January 25th of 2024 that tested positive for methamphetamines and amphetamines. And is that true or not true?
True.
Count 3 alleges that you failed to provide verification of attending the DROP program January 2nd, January 17th, January 20th, January 29th, and February 5th of 2024. Is that true or not true? Count 4 alleges that you're behind in your court-assessed fees as of January 25th of 2024 in the amount of $4,972.61. Is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 4 freely and voluntarily? And did you plead true to those counts because they're actually true? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number
No
one.
objection.
It's admitted. Is there any evidence that Ms. Bowles is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find that you entered your pleas of true to counts 1 through 4 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of the third-degree felony offense of fraudulent use or possession of identifying information. Sentence you in accordance with your agreement to a term of 4 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. That will also run concurrently or at the same time with the Orange County case that you're currently serving any time on. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I've provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk to Mr. Parker. Good luck to you, ma'am. Thank you for being here, sir. Morning, sir. Are you David Wayne James?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment and the motion?
Yes, Your Honor.
Mr. James, in cause number 250522, you're charged with the third-degree felony offense of collision involving serious bodily injury from February 16th of 2025. And how do you plead to that charge?
I plead no contest.
You either did it or you didn't do it.
I plead guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they've charged you with?
Right.
All right. Then I have here on the computer in that case some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, absolutely.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Right, yes.
And it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated. You'd be on probation for 5 years. And is that your understanding of your agreement?
Yes.
Okay.
The other case is, if you can't read my right, it's extended probation and safety relapse.
Okay.
You can read it.
I guess the length of time in the probation is something that, obviously, the length of time on your probation, because it's even written on here, on this one, I can give you any amount of time in probation, so I don't have to follow that 5-year. If I give you the probation and sentence you to probation, the 10-year term in prison, probate it for any number of years, you understand that you'll be waiving your right to appeal.
Next up, a heartbreaking accident that spiraled into a felony. One man lost his life, and another now faces the weight of his choices. Watch closely Judge West's tone shifts from formal to fiery as this tragic story unfolds.
So the thing is, until I see an updated pre-sentence report and really see what's been going on, just on the face of this, it makes me have a little bit of pause because you're already on a felony probation and there's a new felony offense. And so I'm not sure that the length of time of only 5 years is something that I'm willing to go along with, but I'll take a look at it when we come back for sentencing. Do you understand?
Yes.
Your Honor, I've explained that to him, and I've explained to him that some courts don't even consider that. They automatically do it 10, but if you do everything you're supposed to do, the judge can always let you off probation early.
Correct. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1 in that case?
No objection.
It's admitted. Is there any evidence that Mr. James is not competent?
No, Your Honor.
All right, sir, in 250522, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I am going to reset your case so that the probation department can do a pre-sentence report, give me an update, obviously, on the probation case, as well as more information on this offense, and then we'll come back later for sentencing. Now, in cause number 15-23545, I have a second amended motion to revoke your unadjudicated probation. Shows that you were placed on probation November 13th of 2017 for the offense of burglary of a habitation, a second-degree felony, and that was a 10-year deferred probation. Is that correct? This motion alleges that you violated your probation. Count 1 alleges that you committed the new offense of possession of a controlled substance, February 3rd of 2025 in Jefferson County, Texas. And is that true or not true?
It's true.
Count 2 alleges that you committed the offense of possession of drug paraphernalia on February 3rd of 2025. And is that true or not true?
It's true.
Count 3 alleges that you failed to avoid persons or places of disreputable or harmful character, specifically by associating with past associates who are actively using illegal substances. Is that true or not true?
It's true.
Count 4 alleges that you provided a urine sample September 23rd of 2024 that tested positive for cocaine. Is that true or not true? Count 5 alleges that you provided a urine sample January 27th of 2025 that tested positive for methamphetamine. Is that true or not true?
You can hear the guilt in his voice, but will remorse be enough? The law doesn't only punish intent, it punishes actions. And when you're intoxicated behind the wheel saying, I didn't know, can't erase what happened.
Count 6 alleges that you failed. Nope, we're going to keep going. I want to know all of this if I'm going to consider leaving him on probation. Thank you, though. Count 6 alleges that you failed to abstain from the use of any and all intoxicating substances, including alcohol, and that you provided a urine sample on February 3rd of 2025 that tested positive for alcohol. Is that true or not true? Count 7 alleges that you're behind in your court-assessed fees as of February 3rd, 2025 in the amount of $1,689. Is that true or not true?
That's true.
Count 8 alleges that, that doesn't really give me,
Yeah.
all right, I'm going to skip 8. Count 9 alleges that you failed to report to the probation department as directed on February 7th of 2025, and is that true or not true?
It's true.
Count 10 alleges that you were at a location other than your residence at approximately 11:51 p.m. February 16th of 2025. Is that true or not true?
That's true. That's me.
Count 11 alleges that you failed to submit to the alcohol or drug screening as directed February 11th, February 14th, and February 19th of 2025. Is that true or not true?
That's true.
Count 12 alleges that you committed that new offense of collision involving serious bodily injury February 16th of 2025. And is that true or not true?
That's true.
Did you enter your pleas of true to all of the counts except, let's see, 8, which is the one that I left out, freely and voluntarily?
Yes.
And did you plead true to all of those counts because they're actually true?
Yes.
I have here on the computer some documents that have your signature on them in this case as well. Again, did you go over these with Mr. Parker?
Yes.
Do you fully understand them?
Yes.
You understand if I follow the agreement that you've made with the district attorney that you would be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement in this case would be for me to continue your probation, extend it for 2 years, and order you to the Safe B Relapse program. Is that your understanding?
Yes.
15 years the maximum allowed under his plea cap. Judge West doesn't mince words. Accountability matters. And in Texas, fleeing the scene of a fatal accident seals your fate. Do you think the judge made the right call?
State tenders number 1.
No objection.
It's admitted. All right, so I'm going to find that you entered your pleas of true to counts 1 through 12 minus 8 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to reset your case, again, to get an updated report about this case as well as a report about the other case, and we'll come back at a later date for sentencing. All right, you can go back with the bailiff.
Another harsh reality of the justice system, even small violations stack up. Miss BS faced multiple failed tests and missed programs, and now a decade-long probation turns into 4 years behind bars. It's a reminder the system gives chances, but it never forgets.